All right, it's good to be in Florida. Good to see everyone again. It's been a while since I've talked at an AO event, and I'm super happy to be back. I see some familiar faces, some new faces, and to sort of a little quick plug, Hall & Evans is a firm that's been around since 1932. We have about 100 attorneys. We are active in 6 states, which include Colorado, Utah, Wyoming, Montana, Missouri, and Wyoming. I might have repeated a state there. So we're kind of regional in the West. Occasionally I've done some work for people out east. We do all sorts of work, including some of this outdoor recreation and outfitter stuff, including the gamut of things. So time to time I do provide some risk management type services, or looking at forms, or drafting releases, or revising releases. And I encourage everybody in this room, if you want to, you can call me, you can email me with any quick question. If I can help you, I'll help you. If I can't, I'll try to get you to someone who can. And as far as this presentation goes, I encourage questions anytime. You can try to knock me off my game. I'll try to stay on my game. Makes it fun. I will call on people. If you're not paying attention, I'm going to call on you. So pay attention. So first off, we kind of spoke a little bit about me. I'm going to ask a few questions of the people in this room, just so I know who I'm talking to and the things I may be able to say or not say. So first, outfitters. Who works for an outfitter? Okay, who works for somebody other than an outfitter? There's quite a few. Okay, so for those who you raised your hands, I know there's some insurance folks, brokers back there. God forbid there's another attorney in this room who's going to be judging me at every second. And then at this table, what do you guys do? Okay, great. So I think this will apply. It will probably be pretty outfitter-centric, so to speak. And because I'm a Colorado attorney, it may be Colorado-centric to a degree. But I think all the concepts we're going to be talking about are nationwide. So whatever state you're in, I think this will be helpful. Hopefully, I don't think I'll be talking above any of you guys. This isn't like a high-level course. It's sort of a crash course in evidence preservation, if you will, and to try to get the take from a lawyer and how it all plays out later on in litigation, if you will. So here's our learning objectives. I was told to have learning objectives, so that's why I have this here. So just understanding and conceptualizing the importance of identifying and preserving evidence for potential later litigation. And this is not a presentation on investigation, but we're going to be talking about that. These are legal concepts or buzzwords: duty to preserve and spoliation. And no, we're not talking about curdled milk in the fridge. I'm going to talk about and learn about best practices to identify, capture, and store evidence, crafting policies and procedures for evidence capture and investigation. Let me ask anyone here, does your company have a document retention policy in written format? Anybody here have that? Nobody's got that. You've got that, okay. No, it's a document retention report. It's basically how long you keep documents. So it would be like, how long do I keep releases? How long do I keep, if there isn't, okay. So no one here has a document retention policy, which is something that usually the bigger companies have. I'm not telling you all you need to have that, but it's something that you should consider, even if it's sort of a short form, or even if it's unwritten, you need to consider what you need to store and for how long, okay? And then again, you're not going to become investigators here, especially after a 50-minute talk from me. But we do want you to sort of strive to become professional-grade evidence hunters and gatherers. So here's 101 about investigation. It should be done by someone with professional proficiency. And right now, I'm not sure who in this room thinks they're professional investigators or preservers of evidence, but that's what we're going to try to help you figure out. So, people who generally do investigations are lawyers, private investigators, insurance company representatives, and stuff like that. But our investigation is only good if you are helping us be that investigator and helping us find stuff. So, and not anybody can do it. You probably should have someone within your organization designated to be the person, so if there's an incident or whatnot, that person knows it is my responsibility to be the gatherer to find and collect and store documents and other things that may be evidence in the case. And you can only become proficient if you've got some level of education and training. Maybe this 15-minute piece will help train you. Need some experience at it, and you do need to have some good character. And also, you have to have some understanding of the factual and legal issues in the case and what might be relevant to a case. An investigator needs to be objective and be aware of their own biases. You don't want to just have an outcome-driven investigation. You got to have an open mind of what the issues might be and who might have screwed up, who, whatever. You have to have a very open mind when you're doing investigation and collecting evidence towards that. And then your investigation is evidence itself. So how you investigate, what you found, what you did, what you didn't find, that's all part of the evidence in a case as well. So it's not just what you find, but it's how you found it, how you stored it. It becomes an issue in the case sometimes. And of course, you don't want to you don't have all the time in the world. You have families, you have a day-to-day operation to run. You got to be efficient at this stuff. So this is all kind of just to say that there needs to be someone at your company that has some level of training, experience, and the general sort of personality makeup to do this job and to have this task to do in the case of an incident. Who here has had a major incident where they've had either an insurance claim? Well, maybe I should ask this. Who here has not had any incident whatsoever and has not had an insurance claim? Anybody? Okay, you. So you should be taking a lot of notes. So we've all been here. We've all done this. We've all done it to a reasonable degree of quality. Maybe sometimes we made some mistakes. What we want to try to do is keep getting better at this, keep getting better at investigating, and keep getting better at finding out what is evidence and stuff like that. So let's keep going with this. So of course it might be interviews and collecting and gathering statements. When it comes to a rafting fatality or an incident or something like that, it seems pretty obvious that you're going to want to, basically all the guides on the trip are going to be interviewed pretty much. And they may be interviewed by both sheriffs, the governing, bless you, like in Colorado, it's Colorado Parks and Wildlife. Then you'll be asked questions from insurance companies. You might be, plaintiff's counsel or the claimant's family might get a private investigator. They might ask questions. You don't want to talk to them. But there's going to be all sorts of interviews coming in from different sources. And you want to save that. You want to organize that, and you want to have that stuff because later on what's going to happen is those same people are going to have to give a deposition in a lawsuit. So all those prior statements, is information that usually the parties have before that deposition occurs. So the lawyers already know what they're going to say before they even say it because they have these interviews. And taking interviews is important, and this is not a presentation on how to do an interview, but you do want to start setting the narrative of your case from jump. And you need to first figure out what's going on, of course, but you want to sort of set the narrative and have certain things talked about, et cetera. So it's very important to know the various areas where someone might give an interview and being able to collect those and organize those in some sort of organized fashion. Of course, and again, Colorado, it's probably the same for most states. You have to gather information for that day, weather conditions, equipment specifications, et cetera, contact information for guests, reservation information. All that stuff is potentially relevant, and all that stuff needs to be preserved. Again, more of the same sort of the releases that people signed on the trip. Let me stop on that. You really want to gather all the releases of everybody on the trip, quite frankly. Not just the person who was injured, not just the person who died, not just their family, not just the boat. Preserve everybody on that trip, okay? Again, purchase documents, evidence of training, river logs, etc. So let me talk about why that stuff's important. In lawsuits, we think about when a lawsuit occurs that we're talking about what happened on the river. This happened, they high-sided, they went out, they were in the water for, half a minute to a minute and all that stuff. Really, and I think, Leah, you could probably attest to this, our lawsuits become more about the representations made before, the person's understanding of the trip that they signed up for, the type of training they got, or I shouldn't say training, but the safety talk they got, the paddle instructions, things of that nature. The stuff that happens on the river and the actual 30 seconds to a minute that happens before someone is in the water and then when they're retrieved, that stuff is obviously relevant. But there's so much more to relevance and what's discoverable in a lawsuit than just what happened that day in eyewitness observers. They're about the guides, they're about the guide's personality, they're about the guide's training, where they come from, et cetera, et cetera. Do they have their, all the, did they do did they do this, trip before, how many times, et cetera, et cetera. How are they trained, who trained them, who trained the trainers? It almost is endless. It's like a tree that just goes on and on and on and on. So it's important to get all this documentation. If you wait till you get a letter from a lawyer or you wait to get a lawsuit, you're going to be in scramble mode, and a lot of information and data is going to be lost due to time, due to people moving on, people dying, whatever. And you might have a great employee that you think is going to be around in 2 years, but there's a falling out, and then they're in a different state, or they're completely against you, and you don't want that. You want to preserve the evidence as it existed as soon as possible. And then sometimes you have to actually write a report. Okay, so all this is what goes into your investigation, and all of this stuff is what needs to be preserved. And then there might be legal requirements. Do you have to cordon off this? Do you have to cordon off that? Do you have to save the boat? Do you have to save the oars? Do you have to save equipment? What does the governing authority require you to do in that situation? What do they require you to provide to them? You got to do that, and you also have to document your compliance with these legal obligations. Yeah. Photographs of the scene and things like that. Yeah, we will. Let me get to that in a second because I think I'm going to. Well, yeah. Let's not get to the legal stuff. Let's talk about that. So, in Colorado, CPW comes out to the scene pretty quickly, and that's probably true, I'm guessing, in most of the states. Maybe not all of the states. And they always ask to look at the boat, the raft. They usually like to look at the PFD, any helmet, et cetera, et cetera. They will also look for the river logs, each guide's training log, make sure they have the appropriate number of river hours, the appropriate number of training. Sometimes they ask for personnel files. They usually don't ask for the marketing stuff and website and things like that. That becomes important in litigation. And there is a new, I will tell you this if you don't know this, there is a new investigator with CPW in Colorado, way more professional, way more thorough, a much better investigator than they used to do. I can't recall his name, Michael Haskins, I think his name is. But so Colorado's kind of anteed up their game in investigation, and I think we have to do the same. And that's kind of what prompted me to do this investigation and evidence gathering stuff, is that it seems like CPW has sort of employed a different way of investigating, just a little bit more thorough and a little bit more probing, not as friendly. It's still friendly, but they're a little bit more objective. So, yes?
And for those of you in states where you won't have an investigator, which would be a lot of you, like Canada, Utah, things, you're not going to have that investigator, then it's on you.
Yeah. That's a good point. The investigator, sometimes you kind of can gather what's relevant or what needs to be preserved from them. If you don't have that, you're left to your own devices. Let me talk about, for instance, a boat. Boats usually get put back into service after an incident. I strongly encourage you to photograph the hell out of that boat. Not just the registration number, not just the model number, but also, it sounds kind of stupid and basic, but take pictures of the handles. Take pictures of the chicken line. Take pictures of things, because not only is there a duty to do that, maybe not, but it's very impactful when we're in litigation. We can show photographs to witnesses in depositions or at trial. And we can say, so this is, we can point to things, like tangibly. These are things you could have done to hold on to the boat, to stay in the boat, things like that. Now, if we've got a fatality, we're not going to be asking someone that question, obviously. But things like that. It helps to conceptualize and visualize, make tangible the case. So I think more preservation is better. And in today's day and age, you really don't have much by way of, where am I going to store this? You can store it on the computer. You could put all sorts of stuff on a little flash drive. So we don't really have the excuse of like, oh, we don't want to have a big file cabinet full of stuff. All this stuff can be preserved on a little piece of device with a gig, or if not less, maybe even 16 megabytes. So now I'll get legal on you. The duty to preserve, and what happens when you don't preserve evidence. This is just from a specific case from the 10th Circuit, and this is the definition. The duty to preserve arises when a party has noticed that the evidence might be relevant to a reasonably defined future litigation. Let's just assume that if there's a fatality, litigation is reasonably foreseeable. We can go with that, right? Let's assume that if you get a letter from a lawyer, litigation is reasonably foreseeable. Now, what if someone sort of like breaks their ankle and says, I'm fine, like, and they break their ankle in the shop or something like that, or they just hurt themselves. Should we be documenting that? What's your name? Yes. Yeah, Haley. Should we be documenting that? Should we be preserving evidence for that? Yes, okay. Is there any reason not to preserve any sort of evidence on any sort of case? No, preserve it. Now, do you have to go the full bore and do 100% for a little, someone just kind of small injury? Probably not. But I think you're better erring on the side of preserving whatever you can preserve. And you do have to exercise common sense, like what's important. If someone trips and breaks their wrist trying to prevent a slip and fall at your shop, I don't think you need to save things having to do with the trip. It has to do with what happened there. But if it's an actual fatality on the river, you're going to want to save everything from soup to nuts or from birth to death. You want to save everything pretty much. This duty arises even though there's no litigation or even threatened litigation. Again, all it takes is reasonable foreseeability. Now, there is case law that says you don't have to keep everything, but I'm saying keep everything. It says you have the duty, what it knows, what it should know, will likely be requested in reasonably foreseeable litigation. Well, you could say to me, well, Pete, I'm not a lawyer. How would I know what's going to be requested in future litigation? And I'm telling you right now what to expect. Again, any sort of communication with this group or any other group, any sort of representations made on your website or any pamphlets, any sort of training, any sort of hiring, training, you name it. It's basically everything, and I'm not lying. It's like whatever has to do with that trip, whatever has to do with that individuals of those trips, all those things are relevant and discoverable potentially. The courts say it's a flexible, fact-specific standard that allows a court to exercise discretion necessary to confront the myriad factual situations inherent in the spoliation inquiry. I'm a lawyer. I don't know what that means, quite honestly. Again, I'm in the basics. If you suspect someone might sue you, then it's reasonably foreseeable that you'll have litigation. And these are the This is great. They're being understanding. I'm not going to get sued. Well, you can still get sued. But if they're being angry in the moment, you can pretty much assume that that's going to continue and they still might sue. And even if they don't, it's important to have all this stuff saved because it might end up in Leah's hands or my hands, and then it arms us with information. And information's power, whether it's good or bad. If you know the bad stuff, you know the good stuff, it's good. You can work with it. What freaks us out as lawyers is what we don't know. Anyone gotten a letter of representation before? Yep. Again, doesn't mean there's going to be a suit, but you got to treat it as if there would be. Preservation notices have been around for 20 years, but I think lately the plaintiff's bar is getting better at using them. So preservation notice is where they say, I represent so-and-so, in the matter of the June 5th, 2020 incident in which my client tragically and preventably died on the so-and-so river, blah, 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 blah. This is to give you notice of a potential claim. Tell your insurance carrier, please submit this to your insurance company. In the meantime, you need to save all this stuff. And it will talk about physical, tangible things, but it'll also talk about emails and texts and that sort of thing. And if I would say there's any blind spot or things that as an industry we could work on better as far as evidence collection, it's emails and texts and WhatsApp and those sorts of things. And that's not easy to do. So what do you do with this? And, when is reasonably foreseeable? I think your broker, your adjuster, if you have an insurance, they'll tell you save everything. And again, err on the side of capturing more than less.
What would be the, like timeline-wise, like at what point, if like X time has passed, would we be able to not expect?
Good question. Okay, so every state's different, every cause of action is different, but I can tell you that, for instance, in Colorado, it's a 2-year statute of limitations to bring a suit. If a minor is involved, that statute of limitations doesn't start to run until they're 18. So if you have an 11 or 12-year-old and they get injured or something like that, you technically would have an obligation to keep it for quite a long time, like years and years and years. What's that? Indemnities to try to prevent a lawsuit and say, like, you cannot sue us, and if you do, we're going to go after you for the fees we have to expend and stuff like that. And but releases are just a tool. They're not going to prevent a lawsuit. And even if you have the release, it doesn't relieve you of the duty to preserve. And most states, Colorado is one of the best states for releases, but there's some states that have so many exceptions to the rule that it kind of swallows the rule. Yep. Okay. Yes. It protects, willful and wanton conduct or gross negligence or whatever it is. So, in my personal opinion, the release or whatever the law is, these apply to all 50 states, no matter what, across the board. So, because even if they think you have a valid release, they might disagree. They might think that this is an invalid release. Criminal's criminal's another thing. I haven't been involved in a case where any authorities actually brought charges, but I do know anecdotally a few times where it's been threatened or almost happened. But the same deal applies to, I think, criminal, and I don't know any outfitter that's ever been charged criminally as an organization. You haven't heard of any, have you? Okay. So I think what you're really worried about is civil. I mean, not to say, don't commit any crimes, please, but, all right. It's not just, you're not like, I'm going to get rid of this evidence. That's not what spoliation is. Usually spoliation happens when the company doesn't even know it's being spoliated. Oftentimes it's with emails, maybe they get overwritten. Video, if there's video surveillance, that'll get overwritten over time. So you got to make sure to capture the evidence before it disappears. And that includes people's memory. I think it's very important to take everybody's statements as soon as you can after an incident, because what are they going to remember a year from then? And what's their mindset going to be? I can tell you, I have a case right now where a witness came to us. She gave a statement to the police. It's bashing our client. And she came to us and she said, I gave that statement, but that's because I thought X, Y, Z, and now I learned that that's not true, and now I have a change of heart. It also happens if someone gets fired or something like that. They might be your best proponent. They might, walk the company line, but then they leave, and then all of a sudden they're like, oh yeah, that company, man, they don't even know how to train people, and all this dirt can come out. So what you do to shield yourself from someone getting fired or leaving on bad terms and then bashing you is to lock them in when they're still employed by you, because you have a better chance of them kind of towing the company line, if you will. So it can be unintentional, and it oftentimes with video and other things like email that can go away after time. Who's ever heard of a litigation hold? Anyone? You've heard of one. Why aren't you raising your hand? Okay. So again, using sort of bigger companies as a model. For instance, I can think in my mind of a city in Colorado that I represented once. They have a concept called a litigation hold. And we'll talk about this in some detail right now. So it's like there's a notice of a lawsuit. So a litigation hold goes to the people who may have been involved in that, and every single person is told that we have a lawsuit, you need to preserve evidence, that includes text, blah, 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 and so please take the appropriate steps to preserve this. Let's put this in the rafting world for a second and talk about what a litigation hold is. And I'm using this term because it's a term of art, and I'm not saying this is what you need to call it in your practice, but ideally, like a best practice would be, let's say there's an incident, let's say there's a trip leader and then like 6 rafts, so you got a trip leader and 5 other guides. Let's say there's a photographer who's on the trip, let's say there's some support like in a kayak. All those people need to be told that we need to preserve evidence. So if you have any text about this trip, text about the weather or river conditions that day, you need to preserve those and we need to get those from you. And you also want to tell them, keep that chatter to a minimum. You do not want your workforce doing WhatsApp or text and thinking that that's not going to be discoverable, because it could be. And even if it's there and then a year later gone, and they say, well, I don't have that, I changed phones, I lost it, on another trip, it fell in the water and stuff like that. That's not really an excuse anymore. Like that maybe flew 10 years ago, 15 years ago. That stuff doesn't fly anymore. So I think you'd have a duty, and then how are people communicating? Text, emails, mostly text nowadays. I mean, I'm texting with my clients all the time now. So how do you get the text when it's their personal phone? And how do you show the other side that you took your obligation, your duty to preserve seriously, unless you had some sort of directive to those people to preserve information? So you do something like a litigation hold, and it's done by the person that you've designated to do this job, to be the sort of hunter and gatherer of relevant information. And you tell those people, okay, we've had an incident, that means that what you say about this incident is potentially relevant. And what you may say, and these need to be carefully crafted. We can't tell you how to do these in 30 minutes or something. These need to be looked at, etc. But what you do is you tell them, if you sent any texts, you need to preserve them, and please produce them to us. If you've emailed about this incident, please preserve those and send it to them. And you want to have it sent in the right way. If someone took a picture of the river feature that day, you'll want to get a native copy of that photograph. And you got to make sure you're sort of like looking in the areas where you need to look and try to basically, find out what's out there, mine it, get it back, and have it in your possession. So you don't have to bug them later, so you don't have to be fishing around later. So that's the idea of a litigation hold, is you have notice of a reasonably foreseeable litigation or a case. So what you do is you tell the interested people that you know of that you have a potential case, and we need to preserve evidence. It's got to be, even though you've designated one person to do this job, it is a collective obligation of everybody within the corporation. And of course, if they're a rank and file guide or something like that, they're not managerial, you got to get it from them, and then you won't have to bug them about it again. And that's how you want to do it. It's all best at the front end. So back to the courts. Courts have broad discretion to impose all sorts of sanctions. And no, they don't make you dress up in a clown suit and do something like that. It's usually money, or we're going to go over the sanctions, but they can be pretty serious and severe. And again, they don't need to find bad faith or intentional spoliation. And there's case law in all this stuff. And in some states, don't ask me which ones, but I know this to be true, that there's at least a handful of states where it can be an actual cause of action, and you can actually get directly sued for not preserving evidence. So what are the most common sanctions? This is probably the most common, adverse inference instruction, and I'm going to talk about that in a second. One is just like award of costs or reasonable attorney's fees to the other side, sort of like a fine, if you will. That's usually absorbable, especially if you got insurance coverage, but maybe your insurance company would say, well, that's, maybe they won't cover it. So that could be pretty severe as well. This is a very nuclear one where they preclude, it's called claims preclusion or evidence preclusion, and they might say, because you lost a specific piece of evidence, you lost a statement of a guide, you lost some video that showed some, they might say you can't raise a certain defense. And if you can't raise a certain defense, you might be totally screwed in a lawsuit. Also very common is avoiding these more nuclear sanctions and saying, well, I'm going to allow the other side to take a second deposition of this person because you couldn't locate and produce that document. And you're going to pay for the deposition costs, and you're going to pay for the attorney's time, things like that. And then there's this sort of intangible things that go on when you don't have evidence. I mean, you're handcuffing your own lawyers, for one, when we don't have evidence and we're working in the dark. You could lose credibility with the judge. You lose credibility with the opposing counsel. And that's important. Like, we don't really care about the feelings of opposing counsel, but if they're suspicious of you, they're going to then start to dig further and further, and they're going to make our jobs and your lives a living hell during the litigation if they think we're losing evidence or being dishonest and that sort of thing. And it does hurt even though like I might not do anything wrong, it does hurt, I think, the lawyer's credibility to a small extent when our own clients aren't producing things that should have been produced, that they've lost things that they should have saved, things of that nature. So, and it's also, let me go back. Also, if you lose evidence, you could be losing good evidence. You know, it actually could be evidence that helps you in the case. So the adverse inference instruction, I'm going to give you an example here. And it's basically that they failed to preserve evidence. So the jury's going to be told, they'll literally be given a document at the end of the case called a jury instruction. And they're given like 20, 30 different instructions. But there'll be an adverse inference instruction that'll say, Sunshine Rafting Company failed to preserve a piece of evidence, failed to preserve video. And you, ladies and gentlemen of the jury, should assume that the evidence would have been adverse to that party. So that's really tough to work with. And I did have a case. It wasn't a rafting case, but it's called a dram shop case. I was representing a tavern that was alleged to have overserved a guy. They served him 5 Crown Royal shots. Then he went out on the road. He fell asleep at the wheel, went off the road and rammed into 4 cars, and 1 person was killed and 6 or 7 people were injured. So my client said, I got video, and he's perfectly fine because the liability standard was whether he was visibly intoxicated. So he was all proud and said, Pete, I have this evidence. Here's the surveillance video. And he saved about 20 minutes of the guy in the bar when he got served the drink, and he's just sitting at the bar and he's just pounding Crown Royals. Okay, but he didn't save the part where the guy walked into the bar. He didn't save the part where the guy walked out of the bar. So he saved like a fraction of the video. In that case, the plaintiffs got an adverse inference instruction, and the jury was advised to told that he didn't save it, and to assume that the evidence was adverse. So that was a big barrier. We luckily won the case anyway, don't ask me how, but we won the case. But that was like a huge thing in the case, and it was a big concern for everybody involved that he didn't save that information. So. And the reason they do this is they're trying to punish the party for not preserving evidence that they should have, and they're also trying to put the party that wasn't guilty of that, put them back in the position they would have been but for the spoliation. So in my case with the bar that didn't save all the video, I'm pretty confident because this guy was a complete alcoholic, and he could drink, and if he had a 0.3 in his system, he's still going to walk fine. I think if the client had saved that information, it would have actually been helpful. I'm almost convinced. But because it was not preserved, the jury was allowed to infer that it was bad evidence. So, and I think I overcame it because we had a toxicology expert that talked about practice drinkers were able to not show any signs of visible intoxication. So we got over a rebuttable adverse inference instruction, but it wasn't without hiring an expert, spending a lot of money, stress, all that stuff. And the harshness usually depends, if you do it intentionally or it's just grossly, what the hell, why did that happen? The harsher the sanction will be. Now here's a common hypothetical. Let's say there's a rafter that drowns after being ejected. And, of course, the chaos that happens after all that, and you're trying to, again, you've got so many balls in the air. This happens a lot. The PFD that was on the person goes back in the bin. Sometimes it's cut off by by EMTs trying to work on the person to resuscitate the person. But I've had at least 4 or 5 cases where I show up, I'm like, okay, so where's the PFD, or I call, where's the PFD? Oh, it got put back in the bin with all the other stuff. Okay, it happens. Okay, that's happened. But the problem is, one thing that has come up in case after case after case is allegation of the PFD not fitting right. Okay, because it's either the wrong size or the guides failed to ensure that it was snug, and things of that nature. So without the PFD, and again, I mean, it's going to be hard to really kind of test it out later after the fact, but if you don't preserve it, you can pretty much guarantee the plaintiff going to make a big deal out of it. And the plaintiff's the person suing. They're going to make a big deal. Well, where's the vest? Where's the vest? And you can say, well, this is the same vest as all the other vests, but it's better to have the actual vest. If you've got a really small shop and you really, really need to use that vest and put it back into service, or if that happens, like, we can usually overcome it as attorneys, but again, the best practice would be to take that vest, make sure it doesn't get commingled with all the other vests, set it aside if you've got some storage room, set it aside until not only your lawyer can look at it and photographically document it, but until we get like an expert to also do the same. It's important that you get every scrap of evidence and you keep it. So let's say it does go back in the bin. So here's my question to you. So I have, guy dies. Did a duty to preserve the PFD, did it arise? Anyone say no? I'm asking really easy questions, by the way. Okay, of course it arose. Okay, let me ask this question. Let's just randomly, Emma, can I pick on you? Okay, so do you think by the fact, and there's no right or wrong answer, by the way, so did spoliation occur by the fact that the PFD went back in the pile of other PFDs? Do you think spoliation occurred? Okay.
I have a question, because we had an incident,
Uh-huh.
and the sheriff kept the PFD,
Yep.
and then they lost it.
And they lost it. Okay.
So, I mean, it wasn't an issue in our case, but like, is it our duty to photograph, go to the sheriff's department, get all of that evidence? 'Cause
Yeah. So in your case, just roughly, I don't think spoliation occurred by the fact that you didn't photograph. I mean, I think it's a reasonable assumption that a sheriff's going to take good care of evidence. I think, and that's a very good, if someone's going to try to claim spoliation, that's what I'd say.
they wrote a report on it, it was a brand new one.
Right.
Brand new
Right. If you have to give something up, if you get a chance to photograph it, I think that's great. If you don't and it goes to the sheriff, then, and they lose it, well, that's not on you. I will say this, though, because, the authorities sometimes take a while, or they're considering charges and they're doing this, so they might hang on to evidence for 30 days, 60 days, half a year, if not longer. You might need to tickle on your calendar to follow up, is this over and can I get my stuff back? Because even though the sheriff's not going to know sheriff's not going to have anything in his or her brain about, oh, I need to get back to this to them because they have a duty to preserve. That's on the company to follow up with the sheriff, to get the information back from the sheriff, and then to properly inventory it, and if you need to cordon it off and preserve it for litigation, then to do so. So I guess the takeaway from your point, Emma, is make sure that if the sheriff or whoever has collected evidence, if CPW or something like that has collected evidence, you follow up and you make sure you get it back. I think that is a duty that you have to do. You can't be like, oh, well, the sheriff never got back to me, and, well, I didn't know, and blah, blah, blah. I mean, those are excuses, and sometimes they may fly, but I think the better course of action is to follow up with the sheriff if they've taken anything and get that stuff back, okay? Okay, so let's say I'm the judge, and plaintiff has risen this motion up. They've said, okay, Your Honor, we believe that this rafting outfitter did not do the appropriate job. It was an old piece of shit PFD. It was totally beyond its life. It's all stretched out. It was riding up. There was witness saying it was riding up. And that's one reason why the man could not survive. It wasn't properly functioning because it wasn't properly fitted. And Your Honor, even worse than that, we don't even have a chance to explore that theory, to develop the evidence. Because what did they do? They just let that PFD go back in the pile. So we'll never know. We'll never, ever know. And we'll never be able to develop the evidence that we think we would have been able to show had that been preserved. So you're the judge. What's your name, Mr. Abbott? Dustin. Okay, Dustin, you're the judge. What kind of sanction are you going to? Well, you're probably going to say, it's okay. Motion denied, right?
I mean, that's a tough question.
It is a tough question.
I have no idea.
Okay.
That's at least more discovery.
More discovery. Okay. Leo, you're the judge. What are you doing?
An adverse construction inference.
You're doing it? Ugh, come on, Your Honor.
I mean, I think that's the most common outcome.
Yep, that is a common outcome. Now, I haven't had, even though I've had cases, and here's what's great. We have releases. You guys always have to pinch yourself that we have releases in our industry, because most industries don't have that. And I know they're not bulletproof shields, but we have these releases. But I've had cases, it's never really come to a head where someone's filed a motion, but it has been sniffed around a little bit. Well, my argument usually is that, for all practical purposes, a Type 5 PFD, they're all the same. He can talk to any witness he wants to. If he feels like he needs to take additional discovery beyond the limitations, he can do that. He doesn't need the vest. He could establish it through eyewitness testimony. Even if he had this vest, what's he going to do with it? I mean, I hate to say it, but I'd say the dead body's not necessarily going to be in the same condition. There's no way he can test it. So this is all sort of amorphous, and it's hypothetical and theoretical, but truly the vest is not going to provide him any information that he can't already get through other sources. That's how I try to argue it, and hopefully that argument would carry the day, but it may not. So that's why it's important to preserve everything, and it's so easy for that to occur, right? Like, you're dealing with, everyone's stressed, everyone's, emotionally traumatized. You've got all these other customers. You've got, your staff you're worried about. You're getting incoming inquiries from people. And just someone's got to be there to remember to sort of come in with some calm and make sure these steps are done. That the vest is put to the side. That the boat is put to the side. The med kit's put to the side. The oars are put to the side. Now later you can do the documentation because that usually doesn't go anywhere. But in the midst of that very day of the accident, it's the equipment and things like that. Someone's got to go like, okay, we got to get that vest. Like, we got to get this stuff put to the side. So here's just a recap of what we've been talking about up to this point. All right, and I want to stop. What's on people's minds? Does anyone want to ask me a question? Any questions are encouraged. Anyone? Bueller?
Something just like a screenshot of a text thread from a guy with some name on there, you know what I mean? Like that whole water. That question makes sense. Like, how do you prove that text thread?
A text thread? Okay, that's a great question. So let's talk about that. I don't know how much time I have, but 15, thanks. So it used to be in the good old days, well, before even there was no text, but then there was text, and the usual way I would get text is people literally screenshotting their computer and then sending me 19 files of screenshots, each one like 2 megs. I was just like, ugh, this is so like basic. Now that can suffice. That's the bare minimum of what should be done. There's better ways to do it, and I do have some slides on this. But there's software that you can get that can download things and then be converted to a PFD, have all the metadata like from, to, time and date, and it's more of a sort of evidence-worthy, because you need to authenticate this stuff. Any piece of evidence in a lawsuit, any document, any video, needs to come in through a witness. You don't just get to throw around documents in the courtroom. You usually need a witness to either establish the foundation and authenticity of that document, and then to talk about it. They have to have some sort of personal knowledge about it. So with the case of texts, and let's say you have a guide, this is just a wild one, but let's say the guide's like, texts his buddy or something, says, I can't believe we're going out today, we're going to have a bunch of yahoos, I'm sure we're going to have an accident. And then later on, an accident happens. Obviously, that text string would be, I hope we'd never see a text string like that, by the way. But if something like that occurred, and it's usually more nuanced. It's never that smoking gun. What you'd want to do is you'd want to get that phone into some software system where you could pull those things from the system and then have a report generated. There's companies that do that. I mean, there is a do-it-yourself way to do it. But then whoever does it's going to have to be able to explain what they do, because if the other side ever pushes back and says, how do I know these are authentic? How do I know you didn't make these up? How do I know this is the complete set? You're usually not accused of forging stuff, but oftentimes they're like, I don't believe this is everything. I want to know what everything is. So, and I know there's something called like there's Droid for Android, and there's a Touch Pro 16 or something like that. There are actual software systems that do this stuff. But yeah, sometimes I do still get it the old-fashioned way, the snapshots, and it's good to get that because you know it's out there, but for evidence sake, you probably want it a little bit more professionally done.
And if you're working with counsel, which you should be if you have a serious injury to your colleague, you call Pete or you call me, we'll know about that software and say you need to do this, you need to do that, so, I mean, this is all good to know, but it also points out who's been doing this for a long time, you're not going to remember all these details, and that's why.
Right.
I have a question. So litigation to hold.
Yeah.
How does that play to the other guests on the trip?
Like, meaning, do you tell them to hold stuff?
Do you have an obligation
No.
to say?
I don't think so. Now, I can think of vaguely this one case where we learned that someone on the trip had some GoPro. I tried to get a hold of that guy. He was bristled at talking to me. And I said, well, why don't you at least give that to CPW? Like, if you don't want to give it to me because you think I'm some slimy lawyer guy, give it to CPW. But we're trying to preserve evidence. Now, I think I know of at least one outfitter that says in their release, this is kind of like higher level, this is not in the standard release, but says something to the effect that in the case of an accident, like, we will ask you to provide us GoPro, to give them notice that we might ask for GoPro. If you know that, again, is this a duty to preserve? I'd say no, but is it a best practice? And if someone disagrees, and Lee, if you've ever thought of this, but if you know someone has GoPro, should you, and they're a guest, you can't really force them to do anything, but should you ask them, like, we would like to get a copy of that because we expect to be asked for this. Do you mind giving it to us? I think you can do that. The risk is you better preserve it correctly, because you're kind of taking on a duty to preserve that video if you get it. So make sure you're doing it correctly. Make sure it doesn't accidentally something mess up and you're like, oh, sorry, I just corrupted your whatever. You don't want that to happen. But maybe if you don't want to touch it with a 10-foot pole, maybe what you do is you just tell the authorities, I understand that Joe Smith, here's his address, here's his email, he's advised us that he has GoPro video of this, and you let them know. You usually can get that back from a public records request, just, like FOIA, or if it's state in Colorado, it's the Colorado Open Records Act. So you can usually get that back. But if you kind of want, if you're one of these people, you're like, I want to know what that shows, and if you think you have the capabilities of getting it and downloading it, I don't have an issue as a lawyer, you getting it and downloading it. I think that's actually a good thing if you do it right, because then that shows you attempted to get information, and it's, and so that you could preserve and get a better understanding of the truth of what happened. I mean, ideally, that would be nice, but I don't think that's from you gotta, like, one part about investigation is having respect and dignity for everybody involved. So you have to kind of weigh factors, and the short answer is no, I wouldn't do that. And quite frankly, it's probably a bad idea to shove a statement form in front of a face of a person whose husband just died, or a person whose kid just died. I wouldn't even do that. I would just be like, we're gonna live with that uncertainty for now. That person, and this wasn't usually done by CPW all the time in the past, but CPW now is getting really aggressive in getting the version of events of the victims and the victim's family, and really and trying to suss out of them what they think was the issue. So in that sense, no, you got to have respect that they've just gone through a trauma that blows away the minor trauma and inconvenience that your company's dealing with in relation. Just leave them off. Now, I do say You do want to try to get people alone, but again, you're not the police. You can't force people to do things. You're going to have to take what you can get. And if there's another person on the boat that don't know the people who are, impacted, well, they're also going to be traumatized too. So you're going to have to kind of, I think, exercise some level of common sense and judgment about, should I put this in front of their face or not? Because they just went through a trauma. They might not appreciate me shoving this in front of their face. So you kind of got to read the situation. I don't have a hard and fast answer. I have a hard and fast answer to your question initially, no. But I think you have to use some discretion and judgment. Does that make sense? Okay. I'm going to start to go in fast forward mode because I'm running out of time. These are the basics. Video's obvious, photos are obvious. Again, I talked about native, talked about all this stuff. Let's go to web pages and policies. So the other thing I like to do, and told every one of my clients or try to, because it can become kind of a pain in the butt a year or 2 years later. The thing about evidence is you collect it and then it sits there in the can or sits there in the silo. You might not need to reach back into it until 2 years later. So it's a good idea, it's best practice to literally save all of your policies and procedures. If there's a guide manual, if there's an employee manual, if there's a set of policies and procedures, if there's a crisis intervention manual, all that stuff, save it all and put it in the can. Even though it's going to last forever, but you know that was the version in place at the time of the incident. Same with manuals, guidebooks. You'll want to find the manuals or the guidebooks or the training that was actually used by the people who were on the trip. So a trip leader, may have gotten his guidebook 7 years ago. You're going to have to find that, and you want to preserve it. Same with the website. We have IT people at my firm, and when I get a case, I tell my IT people, will you please preserve their entire website, every single page. And we do that because, again, the plaintiffs always try to say, well, this was misrepresented. You said this was class 2, it's really class 3. Or you said this is a world-class adventure, and you never mentioned the risk of X, Y, Z. Because the release alone is not, look, we want to pound these people with defenses. We don't want to just rely on a release. So all these things are things to collect and preserve and then have in the can until the time may come where you may get a lawsuit. So I think I addressed some of this stuff. You do want to tell everyone, limit the email chatter, please. You can talk. If you want to talk freely, talk. Don't put it down in writing, because absolutely everything written down is saved, even if you delete it. And again, Leah said this. Look, I know a lot of rafters that can do this without me at this point, but I still suggest, especially if it's new to you or if you're rusty, you haven't had an incident for 5-10 years, it's a good idea, and you'll probably have to call your insurance carrier and report it anyway. You should be calling us. You should definitely be calling us to help you out and to answer questions and come out if need be, and we can help you through all of this stuff. And this is a slide to just illustrate the fact that good policies happen before an incident ever occurs. Yes, you have to execute in the moment, but you want to have things in place ahead. You need to have the policies and procedures. You need to consider some sort of document retention policy. You need to consider some sort of litigation hold policy. You got to have something like, in the event of the accident, this is what you do. And you literally might have call Leah Corrigan, or you literally might have call Pete Middleton. You could have us in your policies. There's nothing preventing that. I think I am in somebody's policy, because I know someone once asked for that. He said, are you okay with that? I'm like, sure, why not? And so you got to have a chain of command for this stuff too. You don't want things kind of coming together roughshod. This should be organized how you do this. You may want to consider checklists for this stuff. Like, okay, check a box, again, some people can do this in their sleep. Some people have got great memories. If you're a person who likes checklists, make a checklist. Have the checklist before have a standing checklist. Like, these are the things we need to do. And then you can literally check them off as you go. Again, I think when you hire people, even guides, you need to tell them what they should be doing and not doing in the event of a incident. And then I think with ongoing training, annual training, there needs to be some level of retraining going into what you're talking about, guides. What do you do after an incident? What do you not do? How do you give a statement? Things like that. And what should you say in the statement? What should you not say in the statement? I believe all that should be part of training and retraining and hiring. You also know that when you move things in an electronic system, you know you're creating a paper trail of you accessing. Just be aware of that stuff. I don't have anything further to say about it, but. Sorry if I went too fast, people. So how do you store it? And I think this is kind of open to debate, whether you want to put it on the cloud, if you want to just have it in a folder. I haven't seen a lot of companies have incidents, and they have incident logbooks and things like that. Who here, their company has an incident logbook? Okay. It's like maybe 60%. Now that's a treasure trove for plaintiff's lawyers, obviously, but I think you need to have one. You need to know, and even if they're near misses, and that goes into sort of just operations and having a good, you want to know when things go wrong so it doesn't happen again. So I think you need to have, like an incident, and you need to be able to get stuff up if you need to. But as it relates to your incident investigation and gathering evidence for that incident, you really need to have a folder, I think, and put everything in that folder. I have a client, I don't know if Ryan's here. Ryan? No? Great job of, if there's an incident, he hands me a flash drive, and he's like, here you go, Pete. That's how dialed in he is. And I'll look in the flash book, he'll have everything. He'll have the releases, he'll have voicemails recorded, phone conversations recorded in the audio files, he'll have photographs, he'll have sometimes the purchase of the boat or equipment or whatever it is, stuff like that. He'd have everything. And it's good to have backups. You might have it in the system. It should be protected from your rank and file employees, like only the people who need to know or need to access are able to get to it. You don't want to have that open to everybody. And you can obviously, you should give a copy, have a sort of a duplicate copy given to your attorneys, just in case something happens to your system. We have it. That's another backup system in place. And then I think I'm finally on my last slide here. So it's a duty. Remember, it is a duty. And I can't tell you how helpful it is when we're in a case and we're doing depositions or we're producing documents, dealing with the other side, dealing with the judge. When we have our, for lack of a better expression, shit together, I can't tell you how important that is and how slick and professional you guys look when you have all your ducks in the row and you have all your documentation. It shows you're professional, it shows you care, it shows that you're proficient, and you're up on your A game. And that, believe me, that does translate into victory and better outcomes. Now, I have yet to have a outfitter case go to trial. I've had several settle, and I've had a lot settle after dismissal motions or motions for summary judgment motions. And it's all a leverage game, right? Every little piece of evidence can be something that costs you money or saves you money. And if you go to another seminar on insurance, you'll find out how important it is, costs of defense are to your insurability and stuff like that. But the more leverage pieces we have and the less leverage pieces the plaintiff have, the better. So if they have, even if it's a piece of crap spoliation claim, they're going to raise it because it gives them a leverage point. So we're trying to minimize their leverage points against us, and we're trying to maximize our own. If you have things missing and we're scrambling around, then I'm spending my time trying to find that thing and avert crisis rather than working on my offensive part of the claim, trying to win. I'm trying not to get beat as opposed to trying to win the claim. So all these things, even if it never makes it to trial, even if you get a wonderful release, all these things are important. And I also think they can improve operations on the whole. So there you go. Any questions, any comments, anything?
How would this change, or if you knew your guide was negligent?
If you know your guide was negligent.
Like preserving things
So what are you advocating? Like destroy evidence? Rub the guy out? There's degrees. Yeah, I think, yeah, it does, but I think I understand what you're saying is, so you know there's negligence, and then there'd be the concern of like, oh, maybe we want some evidence to disappear or something like that. Not necessarily, but like in your subconscious or whatever. Does it really help to preserve bad evidence? And again, I go back to the duty. You have a duty to do it. But I will say this, and I know Leah can back me up on this, we can deal with bad facts. What we have a harder time doing is like being up at trial and getting surprised, and they're like, what do we do? That's the worst. So if it's a bad fact, if you know there's negligence, number one, I'm going to say this, it's going to sound flippant, but I don't even care if your guide was negligent for our lawsuit because we have the release. What we don't want is it to be reckless, and we don't want it to be willful and wanton. I mean, I do care if there's negligence, but you know what I'm saying. Like, you still want to preserve it. And then if you can find out the nuances of what he did wrong, and you can shape the narrative in a way to make it better. Do you know what I'm saying? I mean, truth is truth, but there's also various ways to attack the truth, and some ways look a lot better than others. So if it's probably even heightens the duty to preserve, because then us lawyers can deal with it, and we can fashion, you can call it spin it if you're cynical, but I would say it's a narrative. It's a narrative, this is what happened, this is why it happened, and we can maybe talk to that person and explain things, and it may seem readily apparent to you that it's negligent, but sometimes there's very good reasons why things happen or don't happen. So like I don't like to assume anything. So just save it anyway, and realize that, well, it could also be we could also try to get the suit settled before it even becomes a suit. Like, oh crap, we know about this, and there's a person in this room that knows about this, but I remember we had a case where we found evidence a day before a mediation. And it was video evidence of the guy with the GoPro, like there was something in the sheriff's report that said there was GoPro on the guy's head, but that they were unable to capture any data from it. Well, that was returned to the plaintiff's family, and they got someone late involved, and a guru actually got the data somehow off this device. They put it on us a day before the mediation. It's video evidence of the guy basically drowning. And it's like, and that scared the crap out of the insurance company, and it definitely led to a better settlement for the plaintiff. So, and I thought in that case, like, man, maybe I should have gone and actually looked for myself to see if that was really no data on that. So there's all these things where you think there's no data, but things are lying around all over the place that can come up and bite you later on. And you have to be kind of cognizant of that fact. So to your point, yeah, save it anyway. We'll deal with it. Okay.
I think too, the worst case scenario for us is if our client looks like a liar.
Yes.
That's what happens. And so Keith's point about the narrative, sometimes guides or owners think, oh, this is negligence, and it's really, we would call it inherent risk. That's how you look at it. So you might think you have something really bad, and you're like, no, that's okay. You can deal with that. That points up why to call and ask them to look into it.
Any other questions? What was that? Download attachments. Oh, God, I should have brought somebody else for this question. Well, downloading, I'm not the person to ask how to do the technical stuff. But I know it's becoming easier and easier and easier. I mean, I gave myself congratulations because I was able to file something with the courts the other day by myself. But there is software out there, and I would get someone who knows this stuff or teach yourself how to do it. I think there's... Oh, I'm sorry. I missed that then. Okay.
I have the answer to that.
You answer it then.
Okay. The front registration desk is going to have information if you want to get the recording of all this. So they're the point person to get that. Any other questions for Peter? I'd like to close it out.
Okay.
Okay.
I'm done.
All right.
Cool.
Yeah.
Thank you. Thanks, everyone.